try to be cognizant of that, but we have so many lawyers, which I'm very happy for, but it's hard to coordinate schedules, obviously. All right, so we have Ms. Frunger. Good morning. How are you today?
Good morning. I'm trying to figure out who is on the screen. I just need to figure out. Okay. So Judge Redford?
Yes, ma'am.
Okay. I'm sorry. It'll just take me one moment.
Oh,
Just
gosh, no. Thank you so much for helping us. We're
appearances.
so grateful. And take whatever time you need.
Who do we have for the plaintiff?
Sharon Allman Road.
On behalf of plaintiff as well, Brandon Brown from Denenberg Tuffley.
And Melvin Butch Hollowell, plaintiff.
And David Dubin for the plaintiff.
And for the defendant?
Just Nate Gamble for the defendants.
Okay, one moment. Okay, I'm all set. Thank you.
All right, and thank you so much, Ms. Frugner. And if at any time there's any confusion or you need either myself or one of our very fine attorneys to identify themselves or repeat what they've said, please interrupt us, and we'll do everything we can to make sure that you're able to make the record that we seek in this hearing.
Okay.
Thank you. All right. All right. Good morning, everyone. Today is Monday, July 29th, 2024. Time is 11:09. Court's called to order, the Michigan Court of Claims. My name is James Redford. I have the privilege of serving the parties in this matter of David Krieger et al. Versus Michigan Department of Education. I don't know why I almost said Department of Education because I saw an E in there someplace. But at any rate, it's obviously Department of Environment and Great Lakes. We'll start with case number 2094MM, and then there are many, many other case numbers that we won't need to go through. And appearing, if we could just have appearances on the record, and we could start with Ms. Allman Road for the plaintiff, and then go around the batting order for plaintiffs and then defense, and then we'll get into our hearings today. Today with me in my chambers are one of the new attorneys for the Michigan Court of Claims and one of the interns who I've had the privilege of working with this summer. So if you see two people behind me saying, hey, trying to get my attention, it's because I'm probably making a mistake and they're going to try to help me correct the record before it becomes finalized. So anyway, Ms. Allman Road.
Sharon Allman Road for the plaintiffs, and I'll be arguing today.
Melvin Butch Hollowell, co-liaison for mass tort plaintiffs.
Brandon Brown for plaintiffs, liaison for the subrogation plaintiff group.
David Dubin here on behalf of the plaintiff, co-liaison counsel for the class group.
Okay, thank you.
And Nathan Gamble, I'm here on behalf of the defendants.
All right, thank you, counsel. The pleadings which bring us together this morning, and I said before we went on the record, I wanted to apologize particularly to Ms. Allman Road for, because I know that her schedule, once I adjourned the hearing because of the internet outages of 2 weeks ago, hers was the most challenging, it looked like, at least on documents I was provided. So thank you for accommodating your schedule, and thank you to the other counsel who are present as well. Anyway, we're here because the people have filed, the defendants have filed a motion to compel. I indicated before we got started, we have a 90-minute sort of running clock starting at 11 because of the IT requirements of another Court of Claims judge that begin at 1 o'clock p.m. today. I don't think we're going to require all that time, but just in the event, as if we're getting closer to it, so everyone sort of understands the finite universe of time that we have. But I appreciate everyone's advocacy. I've read the pleadings. I've talked about it with staff. Be happy to listen to your oral argument in support of your motion, Mr. Gamble. And if I'm looking down, it's because I'm taking notes. It's not because I'm checking to find out where on the Kentucky interstate my spouse is, but just as she returns with her beloved elderly mom and dad that I abandoned there in Nashville yesterday. So, all right, Mr. Gamble.
Thank you, Your Honor. The issue here is whether the parties who are the plaintiffs need to sign the interrogatories that they answered. I think that both parties in this dispute actually agree on what the requirements of the court rules are, which is that the court rules do require the plaintiffs who answer interrogatories to sign them and not the attorneys. And I don't think there's really a dispute about that issue. The plaintiffs have suggested that the case management order altered that requirement in the court rules. I don't think that is correct. The case management order, it accommodates the plaintiff's need to make initial disclosures by replacing that in the initial disclosure process, which would have been pretty onerous for the number of plaintiffs there are, to instead do a standardized fact sheet. The fact sheets are different from these interrogatories. The defendants are not making interrogatory requests for information that is contained on the fact sheets. The case management order didn't replace the defendant's interrogatories with these fact sheets, nor did it change the signature requirement of the court rules. That's just not found in the case management order. I mean,
some of these interrogatories, Mr. Gamble, you're asking for the documents the plaintiffs are relying on, the theories of liability that they're relying on, and I'm not suggesting that's not a very standard discovery in any civil litigation, but who would you suggest has the knowledge to answer that?
Well, when each of the 25 or 30 attorneys filed a complaint, they certified with their signature that they had done a reasonable inquiry of the available evidence and reached a good faith conclusion that the story that their complaints tells is true. And these interrogatories go through each of the stories they tell and ask them what the facts are to support that story. And so we're not asking that all 2,000 or however many individual plaintiffs there are sign these, but the interrogatory responses say that plaintiffs reviewed them, looked through their information, and these are their answers. But now the plaintiffs won't provide the signatures of whoever those plaintiffs are. So we're asking that the parties who prepared them sign them. And if what the plaintiffs are doing is saying that the attorneys can act as fact witnesses in this situation, that opens a whole other door of complication because of the Michigan rules of professional conduct, which prohibit attorneys from acting as fact witnesses. So, Your Honor, it's not correct that each of these interrogatories is what the plaintiffs characterize as a contention interrogatory, where the defendants are saying, tell us why you have an inverse condemnation claim or something like that. There's specific questions about specific factual allegations. For example, explain to us why.
What number of interrogatory?
So, for example, Your Honor, in interrogatory number 2, ask them to explain why they think that these state agencies were in operational control of the Edenville Dam. What are the facts that they reviewed prior to filing this complaint that led them to the reasonable conclusion that that was true? Especially since at the time that these mass complaints were filed, the plaintiffs already knew that the defendants here had to get search warrants in order to even access the property of this dam. So they can't possibly think that these state agencies control the dam they couldn't access without a search warrant. And so and that's just one example. The other examples are like numbers 5, 6, and 11, which ask explain to us why you think that everyone knew that maintaining the normal level of Wixom Lake that it had been set at for nearly 100 years would cause the dam to fail. I mean, what facts are you relying on to make that allegation? Or, for example, interrogatories 8 and 9, the plaintiffs tell this story that Boyce Hydro was trying to repair the dam to keep it from failing, but Eagle and DNR wouldn't let them do it, refused to let them perform repairs. Well, none of this has any relationship to evidence I've seen in the 4 years that I've litigated these cases. And so I'm just wondering, we're entitled, they made the allegation, what are the facts you relied on under 1.109 to come to the conclusion that this is actually true, what you're saying? And at this point, they haven't been willing to offer any witness at all other than attorneys. And so, if that's the position the plaintiffs are taking here, that our 3 attorneys who signed this are going to be the fact witnesses, and page 8.
I'll look forward to counsel's response, but very little surprises me after 38 years. Maybe I'm going to be surprised, and maybe they're going to say, "You're right, Your Honor, Mr. Hollowell, Ms. Almenrod, and Mr. Dubin, we're all fact witnesses now." Maybe that's what counsel is going to say. I think it's probably unlikely, but
Well, frankly, Your Honor, page 7 of their brief says that. They say that counsel were intended to provide the factual answers to defendants' interrogatories, period. I mean, that's their words. And
I get that part, but I don't think that when they said that, they thought, oh, now I'm excluded from being a lawyer in the case. But
that isn't the idea. That's why I've been asking for them to sign the interrogatories by the plaintiffs who prepared them, which is what the court rules require. The CMO didn't change that. The fact that the plaintiffs chose to file lots of lawsuits instead of just 1 or 2 class actions didn't change that. They still have fact witnesses. Someone told them that these allegations were true, I'm assuming, because they signed the complaint before they filed it. And so who is that person? And they're the person who presumably should be signing these interrogatories. And again, I understand their point. It would be one thing if these interrogatories said, like I mentioned, tell us why you have an inverse condemnation claim. I mean, that's really a question for a lawyer. That's not what these interrogatories are asking. They're saying, you tell this story where Boyce Hydro was trying to lower the level in the spring of 2020, and Eagle said no. That story isn't true based on the evidence that the defendants have. So what evidence do the plaintiffs have that I apparently don't that shows that that's true? Who's your witness who thinks that that happened? Because it didn't, based on the witnesses I've talked to and the evidence we've seen. So that's all we're asking, Your Honors, for them to sign these in accordance with the court rules and provide the interrogatory answers the way the court rules require. We don't think the CMO changed those requirements. So, Your Honor, with that, that's really our legal position here.
All right. Okay. You'll have a chance to engage in further discussions with me, but let's hear what Ms. Almenrod has to say on behalf of the plaintiffs.
The first thing is Mr. Gamble mentioned that the purpose of the agreement in the CMO for the fact sheets was a recognition that almost 2,000 people it was going to be very logistically difficult to put together initial disclosures. And it also does mention interrogatories, that those who waive interrogatories regarding similar information, which are largely damaged information, admittedly, these people. There was some issue that came up and arose after we put together the form and Mr. Gamble approved it, whether he expected us to have them sign those still, because it was their individual damages. It was something personal to them. And so we asked him and he agreed, no, you don't have to have them signed. So that's the reason too, we didn't seek a protective order from the court in advance, asking the court that they don't have to sign the interrogatories, because we understood that to mean there was an understanding of the logistical improbability of this. Our best place to look for guidance is not only do the Michigan court rules and statutory law give the court the ability to modify the rules as necessary, if you look to multi-district litigation cases, which are tried frequently in the federal court, the rules in federal court, which are very similar to Michigan court rules, are modified in these instances, often in order to accommodate what the real purpose is. I cited a case called Convergence in the brief, and it's out of the US DC Northern District of California, so it's not authoritative, but it does an outstanding analysis of what the purpose of discovery is, and what discovery requires, and what the court rules when they amended the federal rules to make them so that there were more meet and confers. And the idea was to try and have a cooperative discovery process and to also have a proportional discovery process, that you had to look to good faith and common sense. What information do I really need, and what is the most cost-effective way to get it? Tailoring probes and responses to the real issues in the case at hand. And in here, these people will never be able to answer these questions. These questions go for a hydrologist, geotechnologists, the expert witnesses that we are now working on engaging in order to testify to these matters. Certainly, we have a good faith basis. There's things that circulate in the public domain about what transpired here at the time of the dam failure. But that is not admissible evidence, and we're working on obtaining the admissible evidence. And in the Convergence case, it discussed the fact, just like here, this case involves big economic stakes, and it makes good faith and common sense very important, so that you're not making procedure outweigh whether something is the benefit to the litigation. It's ridiculous to suggest that any of these plaintiffs that are lay people could have signed these interrogatories in good faith. They're asking for factual information, but very technical factual information. They're also asking for what affirmative acts, that's a legal question, we say constitutes the constitutional violation. Those types of questions, all of those are contention interrogatories, and they're outside of the ability of these lay people to answer, sign them, and to be a beneficial component. So the reason for them to sign them is lost. Ultimately, there will be expert testimony proffered. The state will have the opportunity to explore that. And we did answer the interrogatories insofar as we may have had access to any documents that we had discovered in the public domain that we had available to us at that time. Since we answered those interrogatories, the state has been making document productions to us, and we are exploring those. And defendants have access to much of the evidence regarding the alleged misconduct. The most telling source of information about whether the state committed the acts that support the claim for inverse condemnation are the documents controlled by the defendants, which we have now gotten access to. To what the state reports is most of them. And discovery is intended to focus on developing evidence. There isn't evidence that is going to come from John Doe plaintiff who is a resident, not a technical expert.
When I was reading, both your submission and the state submission, I had the same sense that it appears that you're articulating that, if you're the person who has a piece of riparian property that was damaged substantially, your allegation, you're not going to be able to answer so a number of these interrogatories, but somebody has to answer them. Otherwise, it'll be a directed verdict. And I suspect with the quality of lawyers that we have, the failure was May 19th, 2020. On May 22nd, 2020, the first lawsuit was filed. So now we're 4+ years after the fact. This past Friday was when plaintiffs had to submit their experts. I just checked. I don't see it in here. It might have been on my Friday emails. But my concern is in some of these multi-party and multi-district litigation, I'm assuming you're talking about an 18 to 24-month discovery period. The court's not giving you that in this. Discovery closes January 31st of 2025. And if we don't get this somewhat solidified as far as what the theories of culpability are and who's going to articulate the underlying factual basis for these theories of culpability, I don't know how we possibly keep this case moving forward in the time period that I've indicated in the scheduling order. What do you think of those concerns?
Your Honor, nobody wants to move a quick case quicker than a plaintiff does.
No, I know that. I remember.
We have a number of people too and clients who still haven't had any relief and are having economic issues to, repairing their homes and so forth. Most of the people didn't have insurance. But what we have is the 4 years has been a stay of the case.
I know that.
There's not an active pursuit and we don't get it. I'm sorry.
No, please go ahead.
We don't get access to the documents. We get access as we write our complaints through some newspaper article that includes maybe some documents that have gotten into the public domain, that type of information. That's the basis, but that's not admissible evidence. That's not authenticated evidence. And we're just now on July 5th, the state first answered our request for production of documents. They had previously provided us about a month earlier some documents that the state had produced in other litigation, but we had some technical difficulties with that between the two, trying to get them so that they were usable. And then on July 5, for the first time, we got an answer to our RFPs. So when we're answering these interrogatories, we're working through the states because, as the convergence case correctly said, the information is in the control of the state. So now we're working through that, and ultimately it will be in the hands of our experts who will testify to these matters. No matter if we're a year from now or we're at the time, though, that we answered these interrogatories, these lay people will never be able to attest to these matters. And some of them are opinions, an opinion about what the cause is. Underlying each one of these is basically what's the cause?
Right.
Or what is the legal theory behind it? Those are all not questions that these lay people can ever answer. The court has the power, under 602.301 and MCR 2.302F to modify any of the rules or procedures necessary for litigation. And that's what happens in these MDLs all the time, because the goal is to move it along. The time that we will expend getting 2,000 signature, approximately 2,000. I don't want to be held to that number because it's been a moving target.
I am not going to order, or it's highly unlikely. I'm going to, if I grant in any part Mr. Gamble's motion, I am not going to require plaintiffs to get 2,000 signatures. That's not going to happen. But what I do think, I am trying to keep this moving forward, just as all the very capable lawyers are, is I don't think it's unreasonable for a party who's seeking to defend a claim to be able to have an answer of, okay, you say the thing failed and the state knew about it, tell us who. And if it's, Jane Smith is your hydrologist, and she's going to say, because of these 4 things in this report and these 5 other things. Yeah. And I get that that's expert discovery, but it's also fact discovery. And I'm just, when we're looking at a schedule that has, our fact sheets are due tomorrow. Plaintiffs' experts were due this past Friday. I think it was this past Friday, the 26th anyway, of July. Defendants' experts are due August 23rd as far as the list. And then the general witness list is due August 30th. Plaintiffs' expert reports are due September 6th. And I don't mean to suggest that I know what's going on in the defense shop or the plaintiff shop in this case. But I know if I were the lawyer trying this, I think I'd have a rough draft of what my plaintiff's report looks like by now, or something pretty close.
Well, Your Honor, the problem is, as I've said, the documentation. There are documents, for example, of reports that were done when the dam was under the control of FERC. control of the owner and FERC at that point, and those are not available in a public domain. The state did manage to receive those documents when the state sought to obtain them years ago, but those were not in our possession. We only recently got those documents, and those are documents our experts are using. Have they, like many people in the community, formulated an opinion generally about what went on here, but an opinion that will be solid and based on the documents that we have in the record? They're working on that, and they're working on that because they've only recently been given some of the records. They've been relying on public domain information and their own knowledge, education, and experience to formulate their opinions. And that's how we list them. But at the same time, being able to say, oh yes, on June 6th, Mr. Trumbull, one of the state engineers, went there and he did this instead of, didn't recognize this. We're only getting that. We've only recently gotten that information. And then we have to go through it. We have to go through these thousands of documents. And yes, the schedule is very compressed for plaintiffs. I mean, it is a very, very difficult schedule for us to meet and do this. And as I say, we want this case to move. No one wants it to move more than we do and our clients. But it is very compressed for us.
But how put yourself in my shoes? You're the presiding judge, and you want this thing to move because you're the fifth judge who's assigned to it, and you want to be the last judge who's assigned to it before the Court of Appeals reverses me. So, I'm sorry, did I say that out loud? No. What would you do?
I mean, I think when we get the expert reports are due in September, and that's going to be very tight. But certainly if we can file preliminary expert reports then, or answer in some of these MDL cases, in lieu of doing expert reports at that time, you do preliminary where you issue identify and respond to them, and both sides do that. And that type of device would be an alternative.
Okay, what else?
I mean, ultimately, I think the issue is that he isn't challenging that we didn't answer them. He's challenging who signed them. And that's really what's before the court today. But the court is looking at a bigger picture, which I understand and agree that that's an issue here ultimately. But
who do you think should have signed them? I mean, I think because we've got three species of plaintiffs. We have the class action plaintiffs, we have the mass tort plaintiffs, and we're going to talk a little bit more about the mass tort plaintiffs at the next scheduling conference. And then we have the subrogation, loosely calling it that. Don't mean to offend anybody, but it looks like these are subro claims to me. Is that right, Mr. Brown?
Yes, Your Honor.
Okay, so can't we? The class, I assume, has candidates who are going to be the class representatives.
Yes, we do. Okay,
so why wouldn't those individuals, who, whether it's 5 individuals or 20, whatever the number is, I apologize, I should know that, and I don't know. But why wouldn't it be appropriate for the class representatives and the subrogation representatives, a representative of the subrogation class, to be the signatories so that we avoid the someone suggesting later on that counsel can't be counsel of record?
Well, I think Ms. Almirad does make some very good points. I like to build off of that issue to answer Your Honor, and that logistically the biggest issue is, yes, my clients can certainly sign this and we can move forward. But my concern is the issues that Mr. Gamble's raising about their knowledge or lack of knowledge is still going to persist. Yes, they've signed it, but what really is going on is that these are expert-based information, A, that the experts are going to have to really answer, and B, at the end of the day, it's going to need to be based off the documentation that Mr. Gamble just produced at the beginning of this month. And we're not just talking about a handful of documents, we're talking about a large document dump
Are we talking 10,000 pages, a million pages? Anybody know?
Off the top of my head, I do not know. I have devoted an associate. I've hired another document reviewer just from my side. And I know that on the Mass side, they have devoted a significant amount of resources to review this. We're not taking this on a light type of viewpoint. My associate, that's all he's done for the last couple of weeks is do nothing but document review because we view this as being very important. And I think circling
Just
back to
interrupt you. Are the documents provided in a scannable basis so that you can search for keywords?
they are.
Good.
And I think that was the holdup in the initial documents that were produced. And Mr. Gamble, you probably had a little bit more interaction with Miss Almanrod's partner or associate who's coordinating that. But I we're taking this very seriously, and
I don't believe me.
yeah.
If I thought people were blowing this off, we would have had a meeting a lot sooner than we're having. I think we've got people who recognize the import of this from both sides of the case, and I'm very grateful to have the quality counsel that we have, and you have plaintiffs who are feel very much that they have an appropriate and legitimate cause of action against the state, and we have the defense who thinks they have a very appropriate and legitimate defense on liability in this matter before we even get to the issue of damages. So no, I definitely am not getting the impression that people are just, oh, we got to talk to Redford in 2 weeks. We better look at this file. I know that's not what's happening.
And I think what we're trying to do and is trying to is look at form over substance and not be bogged down on taking our precious resources and applying it to getting thousands of signatures on interrogatories when on the Mass side, they've just spent a significant amount of time trying to get these plaintiff fact sheets. And we definitely need those resources in the document review process as well. And
how many fact sheets are going to be filed tomorrow? Approximately.
Your Honor, it will be approximately 2,000. There's between 1,850 to 2,000 plaintiffs that are still on board. When we started out, there were a little over 2,000.
Okay, thank you.
And so from my understanding, that was a significant undertaking on the Mass side and has really pulled their resources. On the class side, it's a much simpler process. And so that's why we've been able to focus really heavily on the document review. And so my concern on this motion is if Mass is supposed to then go off and get a significant portion of their clients or to sign off on these interrogatories, we're not really moving the case forward. Yes, we're getting people to sign off on this that Mr. Gamble then will be able to pick and choose to take a deposition where they'll say, I don't know. But we're not really moving the case forward where we're going to meet that deadline at the end of the day. And that's where my concern is.
Thank you. Mr. Gamble, is this motion directed against the subrogation defendants as well?
Yes, the case
Okay,
management.
that's good. Let me hear from Mr. Brown then. Thank you, Mr. Gamble.
Thank you, Your Honor. I would just reiterate what the co-plaintiffs had mentioned. One of the things I think that's pretty clear is that a lot of these interrogatories are actually expert interrogatories that are sort of cloaked and factual interrogatories. So it seems like one of these things that it may be better directed to the experts in the case, which defense would certainly be entitled to take discovery.
But why? And this is to all four of my fellow lawyers who are now on the plaintiff side of the case. let's assume that that proposition is correct, then why isn't an appropriate response to the interrogatory? This is an expert request. It's not a plaintiff fact request. As soon as we have the expert discovery after we've reviewed the blah, 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 we will supplement the answer. But that's not exactly how it was captioned in the responses. I mean, what are your thoughts as the subrogation plaintiff's lead counsel?
Well, Judge, I think, again, having all of the subrogation plaintiffs or the mass tort plaintiffs to go ahead and sign these things, I don't think is a matter that can be done. Maybe we could supplement the interrogatory responses and reference that they will be addressed in the expert discovery, and do it that way. But I don't think that having each and every subrogation plaintiff sign the interrogatories is something that can be logistically done.
Thank you. Mr. Hallwell, on the subrogation, and I know Ms. Allman-Road is speaking to those issues too. I mean, in that group of sub plaintiffs, do you have individual representatives for the not subrogation, it's the mass tort?
Say that again, Judge.
So we've got class representatives and then we have the subrogation folks, and then we've got the mass tort. Which one are you?
Mass.
Okay.
I'm co-liaison for Mass. So Ms. Allen-Road and I are.
Okay, so that's what I thought. I thought
Okay.
you guys were okay. So, but Ms. Allman-Road, do you have individuals who are sort of the representatives or the lead mass tort plaintiffs, or is that not something that exists?
That does not exist. And
Okay.
there are provisions in Michigan rules, like in federal rules, for doing that.
All right. Ms. Allman-Road, what else would you like to say before I go back to Mr. Gamble?
I just want to add one thing that in our brief at page 8, we cited the Manual on Complex Litigation, which is sort of the federal court Bible on conducting this type of complex litigation. And it talks about contention interrogatories. And they talk about the fact that some judges require the responses to contention interrogatories be signed by counsel. And in our answers to interrogatories, we do say that it hasn't been decided which expert's going to address which issue, which it had not at all at that point in time. We were working really diligently to identify experts at that point, and then it would be supplemented at the time that was discovered. And also, in terms of the fact these being contention interrogatories, we had raised this at one of the pre-trials, but at that point, the court still wanted us to respond to the interrogatories, which we did, but we did not discuss the fact of who would sign them. But in terms of providing the information, we endeavored to do that with what we did have provided available. We had some documents that we had accumulated ourselves, and we provided those to the state at that time.
Do any of the lawyers who have signed the responses, do any of those individuals intend to be witnesses? Ms. Allman-Road, do you know?
They do not.
Okay, I just want to have that on the record that we're all on the same page on that as far as that understanding. Okay. Mr. Gamble, have you heard anything that you want to share any thoughts on?
Yes, Your Honor. I would like to speak on, make two general points. And first, to address kind of the big picture issue that the court is justifiably concerned about. And the counsel for plaintiffs have repeatedly said that they just got documents just a couple of weeks ago, and now they're finally scrambling to look through them. And that's just not how this has happened from the defendant's perspective at all. Really, the document productions in this started back in April when, without even being asked, with a formal discovery request, I put a detailed memo together to all the counsel in this case, explaining to them what information we had, and we are happy to give them if they want it. And we voluntarily made productions to them without any document production requests of thousands and thousands of documents that have already been produced in other litigation. This, Your Honor, is the last of many lawsuits. There has been a lot of litigation already. A lot of documents have been available. Not only that, but there's a 500-page engineering report that's been in the public for 2.5 years that details in exhaustive detail what happened with the dams, the technical aspects of its failure. None of this is having to be reinvented by the experts that were just identified. And so, and all of the document production requests that the defendants have made in response to the actual production requests that the plaintiffs have issued have been timely. We have timely provided them an extensive amount of information. So there has been no delay on our part. We are not dragging our feet. And I also want to point out that the documents that just came to the plaintiffs, they only got them because we volunteered to give them. They didn't even ask for them, but they had only asked for FERC documents from the Federal Energy Regulatory Commission going back to like 2018. And I reminded them that I had explained back in April that we actually have all of the FERC documents. If they want them, they can have them. And they said, sure, we'll take those. And so we gave it to them within a couple of days. They had all that. And so, you know, I just want to make clear for the court's perspective that this is not a situation where suddenly the plaintiffs got a bunch of random documents dumped on their doorstep within the past few weeks. That is not how this has worked. The defendants have been very cooperative, bending over backwards, really trying to make sure that the plaintiffs have all the information available because, like I said, this is the last of many lawsuits that have already been completely adjudicated on these issues. So that's my point on the kind of the big picture issue, Your Honor. As to the specific interrogatories here, the plaintiffs keep either calling these contention interrogatories that should be answered by attorneys or interrogatories that ask for expert analysis. That's not correct. And so if you
How
look,
is it not correct?
so for example, in interrogatory number 5,
Hold on, let me get to it.
or excuse me, interrogatory number 7 is what I meant to direct the court to. This is purely factual. They allege that the people controlling Edenville Dam asked Eagle to lower and keep Wixom Lake below its normal level up until the time of the flood. Now, the documents that they produced to us, they produced 17 documents to us. One of those was the permit request by the people who controlled the Edenville Dam, which said the opposite of what their allegation is. The permit request said, we plan to return Wixom Lake to its normal level before May 2020, in the spring of 2020. And so that's why we asked the interrogatory, well, who have you got? Well, who's telling you that this thing happened that from Eagle's perspective did not happen? And their response is, we don't have any plaintiffs that have this information. So my question is, why are we litigating this? You know, if this is an allegation they made that they're conceding they don't have any evidence in support of, and the evidence that does exist that they have shows that it's not true, this should not be in the complaint. This should not be something that requires the parties or the court's time to adjudicate. And that's just 7. The same is true for number 8. This is not asking for expert analysis. They make an allegation that Eagle and DNR tried to keep Boyce Hydro from repairing the dam. That's not an expert analysis. That's a factual event that they say occurred. So who's telling you this? Why do you think this is true? You know, you made the point, Your Honor, that the first lawsuit was filed within days after this dam failed. I really don't know where the plaintiffs got this information from because it has no relation to the actual evidence that we've seen. And so it's important that we have an answer from them. And the same is true, for example, for interrogatory number 9. You know, they allege that Eagle could have just stopped this big pile of dirt, basically, from impounding water. How? Why do you think that that's true? Who told you that? And so if they don't have any fact witnesses that can explain this, they don't have any documents that can explain it, they should agree to take this stuff out of the complaint, amend the complaint, get rid of these allegations that they know and I know are not supported by evidence. They can't say that, well, we just think this might be true and we're hoping the documents you have will prove it. They had to have made some sort of reasonable inquiry to be confident that this was grounded in fact before they filed this complaint. So far, we're not seeing what that reasonable inquiry was. So, Your Honor, I recognize
Is there, counsel, is there any evidence that you've produced which suggests that the state represented to the dam owners, we are concerned about an endangered species and a lower level of water that you are participating in, and you've got to raise up the water. And if you don't, we're gonna sue you for environmental damages, because that's replete through the complaints.
I'm sorry, you asking me, Your Honor?
Yes,
Oh,
you represent the state in the documents that you've provided. Your position is that just didn't happen. Your position is Eagle never said to the owner of the dam, we got an endangered species problem and you have to raise this. It can't stay at the level you've indicated. You're saying as an officer of the court, there is no evidence to support that.
no, that's not what I'm saying, Your Honor. No one thinks that Boyce Hydro didn't ask to lower the dam over the winter, or excuse me, lower the lake over the winter. We know that it happened. That's not a secret. They dropped it about 7 feet or so, and that exposed so much bottomlands, it put a lot of natural resources in danger. And they said, we want to keep it this low over the winter. And we said, no, you need to return it to its traditional winter level. And they said, no, that has absolutely nothing to do whatsoever with the level of Wixom Lake when it failed. That request from Boyce Hydro was always, we plan to return Wixom Lake to its normal level in the spring of 2020. Eagle never said no.
Okay, so
what?
Hold on, please. So do you agree that agents of the state told the owner of this device, you got to raise the water back up?
Well, yes, when it was at 7 feet over the winter, Your Honor.
So for the entire winter months, 7 more feet of water is applied to this retaining wall. Is that correct?
No.
Okay, what?
They didn't change the water level at all. What they planned on doing is they said, we want to lower the level of Wixom Lake 7 feet for about 3 months. And the state said, and they didn't say it's because we're worried about the dam failing. It had nothing to do with that. They said, we want to lower it over the winter for about 3 months because of ice buildup on the dams. And the state said, we actually think you can manage ice buildup a different way, and you don't need to cause that much damage to the natural resources. And they said, that's what we're going to do anyway. And that's exactly what they did. So they lowered it 3 months, then they returned it to its normal level starting in April 2020, which is what they proposed. That's what their
did anyone from the state tell them in interregnum, if you don't raise it, we're bringing a civil action seeking monetary penalties against you for not raising it back up?
That is not what the letter said. The letter said that if you don't return it to its normal winter level, which is about 3 feet below its normal level, then you will be exposed to potential penalties and a reference to the Attorney General's office.
Okay. Okay, so I want to get to, here I said at the beginning, there's no way this is going to take more than 90 minutes. famous last words from a bunch of a recovering trial lawyer and trial judge now, and a bunch of good lawyers. Do you agree, Mr. Gamble, that as far as setting aside 7, 8, and 9 right now, but do you agree that if you're a riparian property owner that is not some type of hydrological engineer or expert, that in your plaintiff in this case, or a class representative, there are many of these interrogatories that you would have no way to be able to answer? Do you agree with that?
Yes.
Okay. All right. We have
But,
I'm not, hold on.
oh, I apologize, Your Honor.
No, thank you.
I know, I'm just wondering if you have that white swimsuit confirmed on, maybe I'll trade you, I'll see.
No. All right, I'm going to go on mute and silent for a minute and close the video. I'm asking each of my very capable counsel, if you can hear me and the discussions I'm having with my staff, somebody needs to yell and shout, "Stop talking, Judge. We don't want to hear that." It's, so I hope technologically I'm going to be able to do this correctly. But in the event that you hear the melodious sound of my voice, please stop and interrupt me. Okay, everybody understand? Thumbs up? Yes. Okay.
Yes, Judge.
Yes.
All right. All right. Ms. Holmroyd, are there plaintiffs who are going to be fact witnesses for information that's responsive to the information sought in the interrogatories?
No,
Zero.
none that I am aware of. We don't represent all of the clients, but we represent a substantial percentage of them, and none of those clients will be. And from the other firms that I've talked to, I do not believe that any of them have people that would be testifying to these matters.
Mr. Dubin, what about yours? Same question for you, Mr. Brown. Mr. Dubin, you're on mute.
Sorry.
Okay.
Yeah, sorry about that. My clients will be able to be presented to testify, but they will not have knowledge to testify on the matters requested by Mr. Gamble in those interrogatories.
Mr. Brown?
Same, Judge. What we typically do in these situations is the fact witnesses named would be the adjusters on the files from which the damages arise from. So those would be the witnesses named for subrogation, and none of them would be testifying as to the interrogatories that we're discussing today.
Right. Mr. Gamble, if that which counsel just indicated is the case, what, if any, procedural mechanism would satisfy you for them to respond to that?
If they don't have a fact witness and they don't have document evidence to support their key factual allegations who are plaintiffs, then I don't think that there's a genuine issue of material fact that the allegations are true. I don't think that's genuinely in dispute. So I think that
they're not saying they don't have documents, and they're not saying they're not going to have a witness to say, I have reviewed, I'm Joe Smith, the hydrologist, and I have 14 advanced degrees from Cairo to Chicago, and I've reviewed the documents produced by the people of the state of Michigan and have formed these 15 opinions on why absolutely the state caused this. And you're going to have another series of experts who are going to say that is not correct. Either the expert is not qualified, or the opinions of our expert, who's, Dr. X with degrees from Michigan Tech, the Colorado School of Mines, and University of Texas, says all of these things are so. So I don't think they're saying we don't have any evidence, Judge. They're saying our fact plaintiffs, who are the property owners and the business owners that allege to have suffered injuries as a result of the failure of these earthen dams, they're not going to be the ones who are providing that aspect of proofs.
so, oh, I'm sorry, I don't mean to speak over you, Judge.
No, go ahead.
Then who is? If they don't have, because not all of these are asking for expert analysis, Your Honor. This isn't just why the dam failed. And I get why, Mr. Krieger personally himself couldn't give us good answer as to why the dam failed. But a lot of these are flat out factual requests. Why are you alleging something that's true that we don't think is true at all? And if they don't have any witnesses to support it, then I guess I would be satisfied if they just told me who the people are. Who are the people that can support these allegations that we can depose? So if they don't have anybody, then I don't think that there are genuine disputes about some of these facts.
Okay. Well, I'm looking now on another screen at a 64-page document, which was filed on 7/26 at 10 PM, I think PM. And it's captioned plaintiff's identification of merits experts. David Williams, Richard Van Bruggen, Brian Rapolt, L. David Givler, Ronaldo Luna, W. Allen Marr, William Sturdivant.
So
Go ahead.
I would be curious if the plaintiffs will all tell us on the record right now that these experts that they just recently retained, who weren't involved in this, are going to be the fact witnesses for these series of stories that the complaints tell about what happened with the dam. I don't see how they could be. It's hard for me to imagine that it wouldn't be hearsay, that they could offer any admissible evidence. But even where's the hearsay coming from? I mean, what is the source of these stories?
Yeah, and I guess I think stories is a pretty pejorative term, which I'm frankly not enjoying hearing said repeatedly by the representative of the people. If you wanted to say in support of the theory of the case, in support of liability, it's a few more words, but I think it's more appropriate for this type of case that we are engaged in. So with that sort of suggestion, you can argue and state as you wish. But anyway, let's hear, Ms. Almanrode, what's your position in regards to the suggestion?
Our position is, I'm sorry, our position is that we're allowed to introduce the documents from the state. We're allowed to introduce the state's witnesses. And ultimately, our construction of what those documents, what that testimony means, will be for the trier of fact, which is your honor. And it is, when we allege control, the state says, no, we're not in control. That's a factual issue, ultimately to be determined by the court based on the evidence.
But you have to have some documents or testimonial evidence to support that theory, or Mr. Gamble, I think, is correct. I think we'd all agree that if you don't have any evidence at the close of discovery to support a specific aspect of a claim, either summary disposition is granted or partial summary disposition is granted. You agree with that proposition?
I agree with that.
Okay, so how do we get to a point where both sides are able to move forward, get discovery? And part of the value, we all know who have been civil litigators, of interrogatories, requests to admit, is you're putting up the port and starboard running lights of what your opposing party's position is. And you know the channels that you have to navigate through.
I'm sorry. For some reason, the audio is not coming through clearly for me. Is that happening for anybody else?
Yes.
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 Your Honor, your audio is muffled. And I want to get every word.
You're just mumbling,
No, it's not that.
which I say is worthy of transcription in a good day. So I'm sure and we're.
No, it's the audio. I can't understand.
Can you hear me now?
No, it's very, very muffled. Something
Okay.
happened with your
Someone from
connection.
IT. Okay.
No.
It looks to be your connection, because you do have a delay between your audio and the visual at times as well.
Let me see. Can someone from the Court of Claims, Court of Appeals, IT support unmute and tell me what I should do, please?
This is Liz from the clerk's office. I will have Nick look at it. I believe he is on as well. Give me 1 second.
Thank you. Effort. Nope, I figured that's what you're going to say. Okay, thanks. I'm going to try. Bye. All right. I've been told to sign off and to sign back on. See you in a minute. Okay, any better?
Much.
Yes.
Thank
Yes.
you, Judge.
Just told the team, I said, gosh, if I'd only known in business school that fixing computers was so easy, just turn the thing off. I would have done that, been on the early edge of computing. No, I want to thank the Court of Claims staff for helping me through that. I apologize. I'm at a loss of where I was. So I think I commented that it doesn't appear to the court that
I'm
plaintiff-
sorry. I'm sorry. Can you hang on 1 minute? I'm so sorry. I'm having an issue here with,
no problem.
okay, I'm sorry.
No, gosh,
Back
no,
on.
I apologize. Let me see a thumbs up if everybody can hear me.
Oh.
Okay. I was observing before the technological problems that I'm not under the impression that the plaintiffs are saying we don't have any proofs. I think they're and so anyway, but I guess before we recess, and I'm going to take this matter under advisement, issue an opinion order within 2 days is my expectation of where we're going to go on this. But is there anything, Solomon Road, you would like to say on behalf of the plaintiffs? I'm going to give Mr. Campbell an opportunity to speak as well. And any other counsel who wishes to weigh in. Any sort of final summary? I think I have a sense of where things are, but I'd be happy to benefit from anything you'd like to share.
I have nothing further to say, but I'm available to answer any question that the court has.
Okay, thanks. And we're going to take one last break, and I'm going to talk with my staff before I adjourn the hearing. So any of the other plaintiffs' counsel wish to be heard at this time?
No, Your Honor, thank you.
No, Your Honor.
No, Your Honor.
Mr. Gamble, anything on behalf of the state before I dangerously hit mute and no video one last time? And maybe we should all collectively agree, if I can't come back on, we'll officially call it recessed, but we'll be okay. But is there anything else you'd like to share?
No, Your Honor, only to apologize. I don't mean stories in a pejorative sense. I always think of legal proceedings as competing stories. And so what I really just mean is
Thank you. I
allegations.
appreciate that. And I think, we all are, this is what we do every day, but we have lots of individuals who are affected by this in so many ways that it's entirely possible they're watching this. And I don't think that we want to conduct ourselves in a way that we think that this is anything other than a very serious piece of litigation for everybody who's involved. And I know you appreciate that, Mr. Gamble. You have been for multiple years, and all plaintiffs' counsel also do. So I didn't mean to be overly harsh, and I hope I wasn't. But it's such an important, as all cases are. Every piece of litigation is important for the litigants, and I want anyone who's watching it to understand that we all understand that, whether you represent the state or any of the plaintiffs. So, but thank you for sharing that.
Of course, and Your Honor, I do just want to flag for the court that from the perspective of the defendants at this point, there are some key facts here that are not genuinely in dispute. Based on the responses that we've got in the course of this hearing and also the written responses, there are certainly facts that are not genuinely in dispute. And so I just wanted to flag the issue for the court, that's possibly something that could be coming for the court to decide.
Good. All right, let me go offline with counsel and Ms. Frugner for a moment. All right. Thank you. And thanks to my team that's here, team of the court. We're so fortunate to have some outstanding folks that add so much value to our responsibilities in this process. So I'm very grateful for their help. Okay, I'm going to issue a pretty short opinion in order. But before I do that, here's what I want to happen. Okay, so I want Mr. Gamble and Ms. Allman Road to get on the phone sometime today, please. Do both of you have maybe a half hour you could talk to each other today?
Yes.
Yes.
Okay, so what I want you to do is I want you to go through 1 through 14. So that's the universe of the interrogatories, and see if you can agree. This is not a individual plaintiff question. Okay, and I just need a short letter, and then Ms. Allman Road, if you can circle back with your 3 co-counsel and just say, okay, here's what Mr. Gamble and I talked about, and we looked through 1 through fill in the blank, the last one, and we've agreed that it's my position, and I want you to agree with me or tell me you don't agree, that these are not appropriately directed to individual damaged plaintiffs, if you will. Okay. And so, Mr. Gamble suggested 7, 8, and 9 are not that. I don't know. I'm trying to narrow the scope of this, and then to get something really short back to me, a 1-page letter signed by Mr. Gamble and Ms. Allman Road, that says, Judge, we think that these ones are in play. I can tell you right now, I'm working through this just like all of you are, and trying to get to a point where it's workable, so that we can move on in our discovery process and our responsibilities. Does what I just said, do you understand what I said, and does it make any sense to you? Mr. Gamble, it's your motion.
Yes, it does. And so I can talk with Mr. Allman Road and see if there are some we can agree with. And for the filing, Your Honor, is it just an email to the COC clerk address, or do you want it filed on the record?
Just send me just a letter from counsel. Send it to. Let me ask Ruth. Okay, hold on.
Okay.
Okay, Ruth says send it to the clerk. I have rarely found in the 10 years and 3 positions I've had the privilege of serving with Mrs. Thomas that following her advice has led me to a bad place. So if she says send it to the clerk, we send it to the clerk. Okay? That makes, and Ms. Allman Road, did I make sense? And I honestly, and if you don't think I did, please tell me, because I'm not sure it did make sense. But
I understand what you're instructing us to do.
okay. And ideally, if you guys could get something, I don't need anything filed today. Okay, I get that. But if we could get something filed by the end of the day tomorrow, or maybe the midday on Wednesday, that'll give my team and I time to look at it, review the stuff, and then come up with an opinion in order that hopefully moves us a step closer towards working towards trial. So that's what I would like to do, if that's okay with you, Mr. Gamble.
Yep, that's fine. Thank you, Your Honor.
Okay, Ms. Allman Road, on behalf of you and your other the Fab 4 that are on the screen for me for the plaintiffs, is that okay with you?
Thank you, Your Honor. It's satisfactory.
That works, Your Honor.
Thank you, Judge.
All right.
Thank you.
So we're moving forward. I did see that you all have selected a facilitator, Judge Rosen. That's obviously Judge Rosen is legendary in all things related to resolutions. It's not quite the grand bargain, but it's, you know, it's a substantial matter. Does any party have any objection to me reaching out and having a chat with Judge Rosen? Solomon Road?
Absolutely not.
Anybody on behalf of the plaintiffs, any problem with that?
No, Your Honor.
No.
Okay. Mr. Howell, you okay with that too?
It's fine with that, Judge.
Mr. Gamble, any issues?
No, Your Honor.
Okay. I don't know if it's going to be this week, but I wouldn't presume to have the contact without letting you know I'm going to talk to him at some point. So, you know, it's like I've told all of you previously, when I was a circuit judge, I did my own settlement conferences and got about 85% of them resolved. But we choose not to do that in the Court of Claims, and that's I'm one of 4, and that's the way we're going to do it this way. So, okay. Anything further, Mr. Gamble? This was your motion before we adjourn, shortly before the 90-minute mark.
No, nothing further from me, Your Honor. Thank you.
Ms. Almonroad, anything else?
Nothing further.
All right. And I think all plaintiffs' counsel, you're ready to go as well.
Yes, Your Honor.
Absolutely, Your Honor.
Yes, Your Honor.
Thank you. Finally, Ms. Frogner, thank you so much for helping us today. I'm so grateful that you're able to join us. I understand that you used to work with Judge Hoffius. What a legend in Kent Circuit. Oh my
Oh,
God.
how did you know that?
Well, because I work with Ruth Thomas. She knows everything. So
Oh my goodness.
what
Yes.
a wonderful, wonderful gentleman he was. So
Mm.
yeah. All right. Then today is continues still to be July 29th, 2024, Monday. It's 12:28 p.m. and the court is going to be in recess. Thanks everyone for all of your time. I am sorry that we couldn't get it in sooner. Court's in recess on this matter. I'm checking out. Bye.
Thank you, Your Honor.
Thank you.